Good afternoon. Thank you for joining us for the FAR Mandatory Disclosure Rule Silence is Not Golden webinar. I'm Tom Mason, and I'm the practice group leader for the Thompson Hine Government Contracts Practice Group. Today's webinar will discuss the Federal Acquisition Regulations Mandatory Disclosure Rule. With 8 consecutive years of False Claims Act recoveries exceeding $3 billion, there has been significant enforcement pressure added to the rule. Government contractors must face the reality that if they do not detect and disclose potential False Claims Act violations, whistleblowers may do it for them. We will discuss issues relating to both the False Claims Act and the Mandatory Disclosure Rule, including requirements of the Mandatory Disclosure Rule, protecting a company's interests in light of the False Claims Act and the Mandatory Disclosure Rules, DOJ's False Claims Act statistics, and how they're relevant to the MDR, DOJ's recent enforcement memoranda, and their relevance to both the False Claims Act and the Mandatory Disclosure Rule, and implied certification under the Supreme Court case that we know as Escobar, and the related case law developments and their relevance to the False Claims Act and MDR processes. Before we begin, there are a couple of preliminary notes about the materials and the technology that we are using today. Today's program is being recorded and will be available on our website. Questions will be addressed at the end of the program, and we ask that you submit all questions using the question box on your side panel. A copy of this PowerPoint presentation is available in the handout section of the webinar. We've designed this to be a takeaway resource for all the participants. Our presenters will try to address all questions, and in the event we don't have time to get to them all, we will still address your questions and provide an answer following this presentation. Our presenters today include Joe Berger, counsel at Thompson Hine, Greg Bingham, president of the Kenrick Group, Major General Dan Wright, general counsel at Answer. The full bios of our speakers are also available in the handouts section of the webinar material. I would, at this point, like each of the panelists to briefly introduce himself, starting with Joe Berger. Joe?
Thanks, Tom. I'm Joe Berger, counsel in the government contracts practice here at Thompson Hine, where I focus on government contract litigation, bid protests, and regulatory issues.
And hello, I'm Greg Bingham. I'm the president of the Kenrick Group. I'm an accountant, not an attorney, so I'm going to do forensic accounting work often in the context of determining what is fraud or what is credible evidence of fraud. I'm also an adjunct professor at George Washington University, where I teach a course on pricing and cost issues, and I'm also an expert witness in False Claims Act litigation.
Good afternoon. I'm Dan Wright. I'm General Counsel for Answer, also known as Analytic Services Incorporated. We're in our 60th year of providing services of research and development and studies and analysis to primarily government clients within the national security and homeland defense areas. I'm also the prior suspension and debarment authority when I was on active duty in the Army for the Army.
Thank you, and I think we'll kick off beginning on the first slide, and you're reminded that if you do have a question, please put it in the question box and we'll address it. Joe?
Well, to briefly summarize the agenda, we'll cover these areas. Tom's mentioned them, and we'll talk about some recent developments, including DOJ statistics and settlements. And we'll talk about material that's available from the OIG websites. But to briefly introduce, and Tom's summarized the basic issues that we're discussing. The MDR was added to the FAR 10 years ago, so we have 10 years of experience. We've also had 8 years of FCA recoveries above $3 billion each year. And so government contractors face the reality that if they do not detect and disclose potential FCA violations, whistleblowers may do so for them. But as government contractors, we also have the opportunity to disclose potential violations in a manner that can prevent additional violations, and that's consistent with the FAR, the MDR, their contracts, and good corporate citizenship.
Before you go on, if you remember, prior to the mandatory disclosure rule, there was a voluntary disclosure rule. And for 5 years or so, and toward the end of that period, there were basically no voluntary disclosures. People were not taking advantage of the program, which made it, you know, and the regulators turned it into the mandatory disclosure rule that we have now.
That's right, and that was the genesis of the mandatory disclosure rule, frustration by the government with the lack of voluntary disclosures. And so the MDR requires government contractors to disclose certain potential violations of law, specifically when there's credible evidence of a violation of certain criminal laws or the civil FCA. And the FAR clause that we're familiar with, Contractor Code of Business Ethics and Conduct, implements the MDR in all contracts and subcontracts expected to exceed $5.5 million with a performance period of 120 days or more. And with exceptions, it also requires the contractor to establish an ongoing business ethics awareness and compliance program and an internal control system which has standards that are set out in the clause. So best practices require robust compliance with the MDR, the FAR, and statutory, regulatory, and contractual requirements, as well as the company's code of business ethics and conduct. And DOJ's annual statistics are a reminder and incentive for robust corporate compliance. And it's often in the company's best interests to make a disclosure. If it's a mandatory disclosure, it's required, and it may be in the company's best interests to make a voluntary disclosure, even if or when a mandatory disclosure is not required. And Tom, I know we're going to talk about this issue. Do you want to talk about this now? Because this is a topic that comes up frequently, the difference between a mandatory and voluntary disclosure.
Well, I think that Dan has some approach to disclosures, and that is always to think about disclosing. And Dan, why don't you talk about your philosophy that you use at Answer?
Okay, so one of the things that I do is for everybody that comes on board when they get hired in at Answer, and of course periodically when we do our refresher training throughout the year and that sort of thing, is that I talk about the fact that everybody comes from some ethical background, whether that ethical background is within the government or within academia, for the corporation that they worked for before they came to Answer, it doesn't matter. And so essentially I point out to them that our ethical standards are very similar to the government standards that we follow, and I try and make it simple for them. And that is that from our perspective at Answer, there's only one way to do things. We do it the right way. And if they got doubt about it, they can check with their supervisors, they can check with their teammates, they can check with me, and that way everybody is aware that we don't want to have surprises coming up, that somebody did something on the short side for a momentary gain that's going to cost us a long-term penalty because it has to either be reported or it's discovered in some other manner.
Yeah, and I'll interject something. I was talking to a CEO recently, and they were talking, and this is in context of robust corporate compliance. Their comment was sort of things are going to go bad from time to time. But if you have a robust corporate compliance program, you're going to minimize it, and the regulators are not going to blame you as much when things do go badly.
And I think, thanks, Greg. I think that's important. It's also important that everybody within the corporation or the company or even an individual practitioner that's a contractor with the United States government has to understand that the government realizes that. No corporation is perfect. No human being is perfect. And at Answer and a lot of other companies do the same thing. We try not to kill the messenger, and that's stress, so that the people who do report the irregularity or the perceived problem, we take it at face value, we investigate it, and we figure out what's going on with it. And, frankly, I think we tend to undercut the number of anonymous complaints that way. And instead of having anonymous complaints or anonymous whistleblower type things, we end up with people coming forward and saying, "Hey, boss, I messed up. Here's what's going on."
Mm-hmm. And so our disclosures to the government would be almost like a voluntary disclosure, wouldn't it? We want the government to know that we've found the problem, we've spotted the problem, and we're bringing to you a disclosure of that problem with our proposed solution to that problem. Is that a fair statement?
I think so, yeah.
And so, as we talk about this atmosphere of compliance, I'd like for you to comment. In the slides, we put the FAR rules that deal with the requirement to have a contractor code of business ethics and conduct, an employee code of conduct, often an employee handbook. But it's a culture of compliance. It's the important thing I would submit. And Dan, you and I, when we went to school, we were taught that a cadet doesn't lie, cheat, steal, or tolerate one that does. And that's still our employee handbook. Those are the only things that we need to know. We don't need to look up 50 rules and statutes and regulations. This culture of compliance is something that is very relevant to disclosures, because if we've got everybody in the organization focused on compliance and integrity, we'll be able to spot issues and deal with them before they come to a head and we have to make a disclosure. Is that a fair statement, Dan, Greg?
Yes, and I'll just comment on what's on the slide right now, this items B, 1, 2, and 3. Those are all things that can be audited. I don't think of accounting or auditors and business ethics, or I didn't used to think in terms of business ethics and accounting in the same sentence. But with this mandatory disclosure rule, the DCAA, Defense Contract Audit Agency's audit guidance, and the OIG's Offices of Inspector General's audit guidance were updated to reflect the auditing of compliance programs, including business ethics and conduct.
That brings us to, we'll skip through these slides, the requirements, the clauses, and the Code of Business Ethics and Conduct.
The clauses are there for your reference, and I would make one comment before we move into the requirement for disclosure, and that is, note the Code of Business Ethics and Conduct, where a copy of the code is available to each employee. And this makes it everybody's responsibility. This leadership counts here, but everybody in the company should be focused on ethics, and we have a code of compliance. We have these standards that are set forth in policy and by statute and by regulation. But nevertheless, we strive for this culture of compliance. And Greg, I'm going to turn it over to you, and you can.
Before you go there, Tom, if you know, this is probably trite, but I think it's necessary. And if we say everybody's an ethics officer or a compliance officer, and it's good to know and see that when somebody does bring something up, because then you get the understanding that the word is getting out and they do take it to heart and they're practicing it. And you see that at every level, whether it's senior management, middle level management, or the individual employees.
And on this slide, while we're here, this BII, make a copy of the code available to each employee engaged in performance of the contract. So that could be a blast email to all employees. Some companies take it further, and they want each employee to sign a statement saying that they've read and understand and will comply with the code. And other companies will say we will do that annually. So it's just different ways of dealing with that to make sure that you have evidence that you've made sure each of your employees is aware of your code of business ethics and compliance, and that they plan to abide by it.
All good points. Greg, why don't you address the next slide, dealing with the requirement for disclosure?
Okay. And so this is, well, before we move on to Greg, this is the basic requirement of disclosure, which we're all familiar with, which is the requirement to timely disclose to the OIG with a copy to the CO credible evidence of a violation of certain criminal laws under Title 18 or a violation of the civil FCA. But Greg is going to talk about these additional requirements because there are more requirements in this FAR clause.
Before you move on, I'm sorry. were you finished? Yeah, sorry to interrupt. The timely disclose in the first row here, we'll talk about that throughout the hour, but that seems to be one of the critical decision points for many contractors is what is timely. And when you first get a call or something and you haven't yet investigated it, is that timely? Is it you've investigated it, but you haven't proven whether there was fraud or anything that meets the criteria in 3I, A, and B below here? So that's a key point, I'll just say. Thank you. So these additional requirements for business ethics, awareness, and compliance programs, and internal control system. So internal controls is a phrase that I don't believe was in the FAR prior to this mandatory disclosure rule being added to the FAR 10 years ago. Internal controls is a phrase that is in the accounting literature a lot, and it's in the different government audit communities. GAGAS generally approved government auditing standards, and as well as the DCAA's contract audit manual and the like. And what is an internal control? If you think in terms of if you have checks and you have to have two different people sign the check, okay, that's an example of an internal control. In the accounting world, if you have one person that approves an expenditure and another person who actually orders it and a third person who pays for it, so you have the responsibilities for these actions spread among several people. Those are kind of classic examples of internal controls. And so these are these were added. So internal control systems in the context we're talking about here are making sure that you have systems in place to identify or detect or discover things like fraud and then remedy those. Fix and then 13, 14. Okay. So here we've got the contractor standards, and must communicate periodically in a practical matter the contractor standards and procedures related to business ethics, awareness, and compliance program, conducting effective training programs and roles and responsibilities. Now, often in my experience, this turns into a kind of an annual training program. And time charging is a related topic, but often companies have some type of time charging training for employees, sometimes once a year. And so it's, in my experience, some companies have added these types of ethics training to their time charging, which happens once a year. And then at the bottom here, internal control system. A system, some people think that's just a computer system software, but in the definition for our purposes here is people, processes, and software. So it's the combination of those three. So it's a broader view of what is a system. So here we've got established standards and procedures to facilitate timely discovery of improper conduct. And these can things, you know, what in my view, this gets at types of things like what was discovered, if a fraud or improper activity was discovered, what internal control failure allowed that bad act to happen? So what was the internal control failure? And then how do you fix the internal controls so that that bad act can't happen in the future? And then later, has it been fixed? So those are all things that the audit community can come in and look at with respect to each one of bad acts that may happen. And this auditors can test the types of things we're talking about here, the periodic reviews of company business practices, policies, procedures, and internal controls. So does the existence of policies, procedures, and internal controls prevent fraud? It can't absolutely prevent fraud, but it makes it more difficult. And if your employees are trained in their policies and procedures, and you have robust internal controls, it makes it more difficult, more unlikely to happen. And here we talk about hotlines a little bit, and Dan made a comment earlier about how it's you can't shoot the messenger when people call the hotline and report something. In my experience, the majority, maybe the vast majority of things reported on hotlines are someone not understanding the systems or personnel. You know, they saying that they've been passed over for promotion or something of that nature, or that it's something that if they understood the systems, they would realize there was nothing untoward or unusual happening. And so it would be easy for company management to get frustrated with those types of calls. But it's important not to. You want to encourage people to come forward, and if they detect anything that's the least bit wrong in their view, to make a call, to come forward about it.
Greg, I'll be frank. We encourage them to use our anonymous hotline, or they can do confidential reporting, whatever way they want to do it, or they can throw it over the transom into my office. It doesn't matter. But I'd rather they do this than call the IG, which they can do, of course. And I think somewhere later we'll have the information about the posters and posting the hotline for the DOD IG or whatever government agency you happen to be working for.
Mm-hmm. Thank you. And here you can just see, again, it's the timely disclosure to an agency, to the agency OIG, and a copy to the contracting officer once you have credible evidence that there has been committed a violation of the federal criminal law involving fraud, et cetera, or a violation of the civil False Claims Act.
That brings us to subcontracts. There's a flow down requirement, which makes the clause and these requirements applicable under these conditions. And we want to look at the additional parts of the FAR where the rule is implemented. Concerning suspension and debarment, the important point here is whether the clause is applicable or not, a contractor can still be suspended or debarred for knowing failure to disclose. And in the suspension and debarment provisions, we see the additional requirement for disclosure of a significant overpayment and the possibility of suspension and debarment for knowing failure by a principal to timely disclose credible evidence of a significant overpayment. We also have the role of the contract officer who, when notified of a possible violation, will coordinate with the OIG and take action under agency procedures. And again, we have provisions in the FAR where the FAR addresses causes for debarment and suspension. The MDR added this provision of knowing failure to disclose a significant overpayment. And Tom, I wanted to ask, since the regulation here is ambiguous, requiring disclosure to the government, what is the best practice as to who to disclose a significant overpayment to?
Well, I think the way that I've always looked at this is that I want to disclose it to, if I'm making a disclosure, I want to make it to the OIG, but I also make it to the contracting officer as well. And if DCAA would be involved, I would make it to the DCAA official as well. We want to be making a disclosure, identifying clearly the problem, and we want to be also providing some information about what we're doing to remedy the problem. And I think that that probably matches Greg and Dan's practice as well. I know that the government will try to take a False Claims Act case and harmonize several remedies that they may have. Remedies under the contract, they certainly have civil remedies, criminal remedies, and also some administrative remedies, which we've been talking about with suspension and debarment. So we want to take a look at all of the cognizant of all of those remedies the government has if we're a contractor, but really we want to make the disclosure to an OIG and I believe the contracting officer of the contract that might be impacted. Other thoughts, Dan or Greg?
No, well, I'd just say in the accounting area, sometimes it's hard to know if there are multiple agencies involved. If the company sells more, then there's the TACO, the corporate ACO, might be the right person to cover it, just to make sure that you're covering all the different relevant agencies.
And it's worth noting here that in the DoD OIG semi-annual reports to Congress, they include the categories of their disclosures, and those include significant overpayments. And that brings us to the issue of credible evidence, not specifically defined, but it's been discussed in the ABA guide, and it was addressed in the preamble to the final rule 10 years ago. And a few points to make from that preamble. Until the contractor has determined the evidence is credible, there can be no knowing failure to timely disclose. It's worth noting that when the final rule was published, again in 2008, the rule noted that the statute had been last amended in 1986, but that there were cases that interpret the elements of a civil FCA violation, including claim, falsity, knowledge, and damages. And of course, right after the rule was published in 2008, the statute was amended in 2009, again in 2010. And so it's important to see that the rule, the preamble, acknowledged that genuine disputes over the proper application of the civil FCA may be considered in evaluating whether the contractor knowingly failed to disclose a violation of the civil FCA. Again, this relates to credible evidence, which is undefined by the rule, but which permits a reasonable investigation and a consideration of the various elements of the civil FCA.
Dan, how much investigative effort do you undertake if you're trying to determine whether you have reached the credible evidence standard?
This is hypothetical answer, of course. Answer with a W, not just A-N-S-E-R. I think, you know, it depends, but the point is that we get an allegation, perhaps, whether it comes in anonymously or it comes forward from some employee somewhere, and they say that X is happening. Well, that's a statement, and you got to take it at face value, and we take a look at it. And initially, we may ask the particular managers or the program manager that's involved, what's their take on it? And sometimes that satisfies the information, and sometimes, like Greg said, there's a misunderstanding, and so that gets resolved. Well, I would hate to have had already called up the IG and reported us when we determined that the individual was confused to their reporting mechanisms or their timekeeping mechanisms or whatever that they're supposed to be following. So, you know, that's sort of the obvious one. The one that gets difficult is you find out, yeah, okay, we didn't probably do exactly right here. And typically, again, outside now from the program manager's chain, so to speak, you're going to probably have somebody take a look at it, another officer in the corporation or another manager, somebody from our CFO office or whatever the relevant program might be, and have them take a look at it. Now, time, yeah, I would hope something that we could get it resolved within 72 hours or so, at least within a work week. And that way, I think we'd be credible when we say to the government, we couldn't find anything credible for that period of time. But if an investigation drags on for weeks and weeks and months, I think your credibility kind of gets undercut.
Mm-hmm. I'll say that the resources involved in quickly getting on top of it. Sometimes, I mean, you've got your day job, you've got other responsibilities, but this comes in and you've got to investigate it fairly quickly. And sometimes this investigation can be things like getting someone's email traffic or text messages or something of that nature and spending a lot of time going through it. Well, that can take a lot of time.
So let's quickly go through some of the key provisions, and we'll briefly discuss implied certification. And we're not going to go through every slide, but we wanted you to have them for reference. But we'll just quickly go through these slides. And we wanted to mention the ABA guide is here as a reference. It covers key issues. It's an important resource. But you know the key FCA provisions, and this is not the entire FCA, but the first couple of bases of liability and some key definitions, which leads to the key elements. that we're also familiar with: falsity, scienter, materiality, and there must be a claim. And materiality was added the definition to the statute by FARA in 2009, and claim was redefined also by the same amendment. And there are related defenses to keep in mind, which are also relevant to implied certification of government knowledge, reasonable contractual interpretations, and reasonable regulatory interpretations, which brings us into implied certification. I'm going to zip through these slides, but as you know, 2 years ago, the U.S. Supreme Court endorsed the implied certification theory in certain circumstances. The court stated that concerns over open-ended liability can be addressed through the requirements of materiality and scienter. The court there focused on the rigorous materiality requirement, stating the standard is demanding. And if the government pays a particular claim, despite its knowledge that requirements were violated, that's very strong evidence that those requirements are not material. And Greg, I know you have some experience with this issue, right?
Well, yes, thank you. So this comes up in I've testified as an expert witness in False Claims Act litigation where I was talking about practices in the industry related to the government's knowledge and the payment of invoices. And so, often it's the case when the government is aware of some issue or someone makes an allegation related to a contractor, the government will kick off an investigation, but will they stop making payments? In many instances, they don't stop making payments. They continue to make payments throughout while they investigate it, because many investigations turn out to not bear fruit or not turn up anything that is in poor activities. One thing about invoicing the federal government is that if the allowable cost and payment clause is part of the contract, and it is in many contracts, it indicates that payments are provisional. And that the government, I'll put on the government hat for just a moment, might say, well, we don't have time when we receive an invoice to really evaluate every aspect of that invoice. So we do some very cursory checks, and then we pay the invoice. And then later, once there's final indirect rates are available or we're close to contract closeout, then we conduct audits, more leisurely. So any payment we make along the way is provisional. I don't think that nuance has come up in the cases that I've heard about. But it's this evidence related to the government's knowledge and the government continue to pay is something that I've heard about in a number of the cases.
And the case law is in flux. This past year, we had 2 huge jury verdicts erased based on materiality. And it may go back to the Supreme Court. The court asked for the views of the Solicitor General in a particular case involving materiality. There's also the 2-part test. The court in this case said that the claim must make specific representations, and second, those representations are misleading. And this 2-part test has been the subject of a 9th Circuit case, arguments in December, with DOJ arguing that the 2-part test is not mandatory, and we'll see how the 9th Circuit rules. And that brings us to scienter, and here's a quote from an important case decision from the D.C. District involving the Trade Agreements Act. And we also wanted to mention this decision of the D.C. Circuit, also based on scienter and ambiguity of a regulatory term. This is important to keep in mind. And this case was really focused on the issue of ambiguity. But ambiguity doesn't necessarily foreclose a finding of scienter. But we also wanted to point out the FCA, it covers not just intent to defraud, but obvious deficiencies in a claim, including a failure to make a minimal examination of records. And we also wanted to point out a key finding from the D.C. Circuit in the SAIC case, that allegations of collective knowledge may be insufficient. And so these are key defenses under Escobar, and regardless of how the case law develops, they'll remain key issues under Escobar, and they can be considered in MDR analysis. And that brings us to Inspector General guidance.
Yes, thank you. So in this section, I just wanted to make the viewers aware of some of the resources that are available, both from the Department of Defense OIG and the Health and Human Services OIG. So there is as you can see on the slide now, there is a contractor's guide to submitting a disclosure, and there's a form that can be filled out, and there's various information related to it. I think I'll just read the bolded sentence here at the very bottom of the page. Prompt disclosure, full cooperation, complete access to necessary records, restitution, and adequate corrective actions are key indicators of an attitude of contractor integrity, even in the wake of disclosures of potential criminal activity. They're putting it out there. This is kind of what we expect and what we will view positively. The audit community, well, so the accounting audit community, the DCAA as an example, they have guidance that says, ascertaining whether something is fraudulent is kind of beyond the scope of a person with just accounting skills. And to determine something's fraudulent, you have to determine the intent of the individual, and that's beyond accounting. But accounting personnel do see lots of business records, and they do see lots of, detect trends. And so this guidance is to help auditors when they see something that, that might be a trend that is worth noting, that they should investigate it further and maybe make others aware of it. And so there's a lot of red flags. There's a lot of hypothetical examples. It's sort of like training material for a fraud examiner, is the way it strikes me. Okay, the DoD IG makes these semi-annual reports to Congress where they say the number of cases and the types of cases, and you can see here for the most recent 6 months, April 1, 17 to September 30, 17, that labor mischarging of the different categories listed here, labor mischarging is 74% of the total. And that's fairly common. On the slide now is the previous 6 months, and the labor mischarging part was 87%. And so labor mischarging is harder to get right in many areas. When you think about other, like accounts payable or accounts receivable or many other areas of accounting, you can have a relatively small group of people that can be highly trained, and you can have processes over them. Labor recording your labor time, if you have 100 employees, maybe all 100 record their labor. And so getting consistency among the different people with regard to how they report their labor can be a challenge.
Greg, what's your comment with respect to the number of disclosures that you see here?
I'm not surprised by the number of disclosures. I don't think it's overly high, and pointing out on the slide right now, 3,292 cases, and they closed 3,614. I would be interested to know how many of those come from government entities, like say an auditor that detects something and goes to their supervisor, and the supervisor says, no, that's the normal part of the process, and then they are not satisfied with that and they call the hotline, or they make some kind of disclosure. Versus company people. I would guess the majority of these are vast majority, frankly, are company.
I got to tell you, I'm heartened by the fact that almost all the ones that roll into the criminal area are relatively small in number, and that we would assume that most of the labor mischarging is inadvertent and not intentional. So that I think from the government's perspective, they want nothing. They want no problems, no irregularities, right. But it's probably better that much fewer on the side of which are false or counterfeit or fraud.
Yeah.
And do you see labor mischarging as a function of individual employees not filling out or completing time cards properly, or a problem with the cost accounting system?
I think of it as, this is Greg, as mainly a cost accounting type issue. I'll say that sometimes it's just someone has their administrative assistant put in their time, and they say, put in 8 hours a day toward a particular project unless I tell you differently. And they get in the habit of doing that, and they go on vacation and they still put in 8 hours a day to that, or they work a 12-hour day instead of 8 hours, or they take a half a day of vacation or something, but there's no change. It's just a metronome, 8 hours a day. That's a poor practice. Is it fraud? I mean, it can cause misbilling.
This is Dan. I agree with Greg, but I think it's a combination. You have employees who are blasé about recording their time, and then you have managers who don't check as well as they should. And you have that manager certification every time the time card goes in. And I think it's important, and we probably don't do it as much as we should, but to come down and check what are the managers actually certifying.
Mm-hmm.
And just a comment, why is there so many labor mischarging cases and only 8 significant overpayment? Is there a reluctance to disclose that in your views?
I don't. Well, the labor mischarging might result in an underbilling or something other than overpayment, and so that could be. And I'll just piling on, so to speak, on labor mischarging. But you can. I've heard of circumstances where, like say, a program manager is briefing personnel that are working on multiple projects, and they're saying, we really have a tight budget on this project. Really be careful in how you report your time. And then because we have such a tight budget, but these other projects we're working on, it's okay. And they're kind of implying that, be very, it's okay to charge to one and work on another, or that's, and that's bad. I mean, that's just bad. So there are hotline reporting and different statistics related to that, and the Health and Human Services, I'm going to skip on by this, but the Health and Human Services also has a very robust OIG program that is worth, if you're working in that area and you're considering a disclosure, to visit the website and review it closely.
So I'll talk real briefly about some of the recent developments. We wanted to mention this article from Bloomberg, which is pretty interesting. 9 years in, and recognizing a total of about 2,000 disclosures to DOD, a smaller number to other agencies, also recognizing that key terms are undefined. And Bloomberg observed that few companies have been suspended or debarred, but individual suspensions and debarments, that is, of individual persons, have gone up. Bloomberg also noted the issue here of what it calls a soft disclosure, where disclosure goes to the wrong place or the wrong person, not to the OIG, which is a reminder that if it falls under the rule, it needs to go to the OIG. And their numbers, the numbers reported by Bloomberg are interesting. Bloomberg reported a total of about 200-something each year until last year when the numbers went up, and they were reporting a partial year. We looked at the semi-annual report and found that the number was even higher, a sharp increase in 2017. It may have been due to a change in administrations, but we'll see where it goes next year. And that brings us, and I'll go briefly through the DOJ annual enforcement statistics, but they are an important reminder of what to keep in mind and what DOJ is focusing on. And the numbers are big, and it's the 8th year of FCA recoveries above $3 billion, this year 3.7, of which 3.4 resulted from KETAM cases.
In KETAM cases, for those who may not know, are whistleblower cases where an employee or another interested party reports what they perceive to be the misconduct.
And the statistics also show the number of KETAM cases, the number of new KETAM matters, here above 600, and 125 non-KETAM matters. And those are close to the average for the past decade, but it's also a good point to point out that disclosure, an MDR disclosure, doesn't preclude a relator lawsuit or a DOJ lawsuit, but it can provide defenses and demonstrates good faith and ethical behavior. And for the Defense Department, it's worth noting that the number of new HETAM cases last year was down, the lowest in 30 years. And there could be different explanations, but hopefully they include a measure of success for DoD anti-fraud programs, including the MDR program. DOJ focuses in its press release on procurement fraud each year and provides some examples, and these are just some examples. But these examples are consistent with the types of allegations that are frequently the type of allegations that government contractors are faced with, and they include the implied certification theory. DOJ's press release also highlights diverse areas, and it's a reminder that potential FCA problems can arise in any of these areas. And we also wanted to briefly highlight some emerging areas of enforcement. These have been talked about a lot over the last year. The Buy American Act, the Berry Amendment, and related laws. Thompson Hine put out this alert. Trump administration steps up Buy American enforcement, but that could have been the headline of any of dozens of articles over the past year.
And these result in what we would call a reverse False Claims Act case, where a contractor is supposed to pay a tariff or a license fee and they do not. And so the government has not been paid the fee that they were, believe are due and owing. And so these False Claims Act enforcement cases result from that. They're pretty much in the domestic preference trade area.
And we highlight these DFARS clauses in cybersecurity and counterfeit parts. These are recent, either recent clauses or recent versions of these clauses. And as you know, the NIST requirements went into effect at the end of last year. Greg, do you want to talk about this one?
Yeah, just one more slide. Yeah, and so this is a recent rule related to voluntary disclosure of defective pricing, and this is for circumstances where the contractor identifies that there may have been defective pricing after the award of the contract. And so the DoD contracting officers have the discretion to do a limited scope or a full scope audit based on the circumstances. That's enough said about that one, I believe.
And Greg, I think we're also going back to you to talk about the next settlements. It's worth noting small business issues are a frequent issue under the FCA, as we discussed, labor mischarges.
Yes, yes. And one more thing about labor mischarges is that why would someone commit fraud? Sometimes people focus on, to make money, to increase their paycheck or something of that nature. But in my experience, often it's to benefit their company in some way that's not going to necessarily affect their paycheck. It's just, I don't want my company to lose money on a particular contract. I want them to do well. Or if they have a budget of so many hours to get something done, and they have like too big of a budget in their view in one area and too small of a budget in another area, they just work on one and charge to the other to kind of make things work out. Or a couple of examples I've seen. So it's not benefiting the employee in any financial sense, but it's just helps them reach goals that they're attempting to reach. And an example here is on the screen right now, relates to Inchcape Shipping Services. Very recent articles coming out of $20 million to resolve allegations of bad acts against the U.S. Navy. And if you go to the next one, this Washington Post article has much of the same information as the press release did. But then the next one related to Inchcape follows the Fat Leonard scandal. And Tom, did you have anything you wanted to add here related?
I think the Fat Leonard case is a good case for anybody that's practicing and government contracting to take a look at and read. There's plenty of material in the public media about the Fat Leonard case, but essentially it was a case where Fat Leonard, Glenn Defense Marine is the name of the company, coaxed the Navy to bring its ships to various ports, and they provided ship repair, they provided resupply, but at the same time, the sailors on board these ships received all kinds of gifts and gratuities, and ended up in return getting information about when the ships were going to come in, when the contracts could be awarded, and there was just a lot of bad acts, criminal offenses committed, etc. But as I look at this, we see very, very easy behavior to spot as being illegal and not ethical, and yet it was done by a lot of different people. But we also see the impact on the government employees was much different from the impact on the contractor employees. And on our side, the contractor employees, every single case ended up with a charge of making a false statement, lying, submitting a fraudulent claim, and conspiracy to do all of the above. And that's conspiracy charge for the contractors added much more prison time, whereas on the government side, some of the punishment was not to the same degree. It was very devastating. You might lose a security clearance and get a fine. You might be given non-judicial punishment, which is discipline, but it's not a court proceeding. Be early retirements in addition to a few people getting some prison time. But it was the contracting side that was punished greatly for this misconduct. And if you read these cases, you will not believe the types of misconduct that was involved. And so I would say this is an aberration from what we normally deal with. And it's a great case to read. It's in some ways entertaining, but we're really focused on what's happening in the company every day and what kind of controls we have in place and how to spot things that need to be corrected before we have to make a disclosure.
So I'll just briefly, for a couple of minutes, explain the DOJ enforcement memos. We wanted to mention these. They're relevant to the FCA and therefore the MDR. I'm sure you're familiar with the Granston memo, which indicates DOJ may take a more proactive approach to dismissing complaints. DOJ decisions are not going to have a direct connection to company MDR decisions, but the issues may overlap. And so the better prepared a company is through its MDR analysis, the better prepared it will be to discuss the issues with DOJ if and when that time comes. The brand memo is also important with respect to policy guidance. It indicates DOJ's not going to use policy guidance or rely on it to initiate FCA lawsuits. But we want to emphasize that doesn't mean that guidance documents don't apply. They do still apply. In fact, they're incorporated often, frequently, into contracts. And therefore, that memo does not relieve contractual or compliance obligations. And we wanted to mention, just as an example, the DFARS clause, because DFARS clauses in general incorporate a huge amount of guidance. In this case, from the NIST, from FedRAMP, from the CUI, and that's part of the clause. And so contractors still have to comply. And this clause, we expect, will be subject of an enforcement action under the FCA if it hasn't already. And therefore, this clause, like others, similar clauses, could be a subject of potential disclosures under the MDR.
And I will say a word about the NIST clauses under the DFARS. Anybody that's in contract management or working directly with the contract, you should inspect every contract to see which DFAR clauses are incorporated into the contract, because the NIST itself does not have any mechanism to make its provisions mandatory. Those provisions have to be affirmatively placed in a contract before a contractor is going to be subjected to those clauses. So you have to check.
And that brings us to our last segment, which I'll hand over to Greg, which has a number of hypothetical scenarios from the DoD OIG.
Mm-hmm. And I'll cover this, but just to the other speakers, if there are wrap-up points you want to make before we close in 3 minutes or so, please give me the high sign and I'll be quiet. But so this relates to the different Department of Defense OIG resources as well as other audit community resources. And I'm starting here with the DCAA. They came out with a memo to regional directors in 2011, a few years after the MRD had been published. And at that time, the DCAA's audit guidance was significantly rewritten, especially Chapter 5, which is the chapter on internal controls and related to so that they could add information on the auditing of integrity and ethical values. And remember, at the time, there was quite a controversy of why are accountants auditing integrity and ethical values, but it's kind of become now to be just part of the landscape. But that was new for the DCAA community. There are, at the DoD OIG's website, there are many different fraud detection resources. So it's more than anything else training materials and red flags. So examples of things for auditors: if you see the following, consider what could be causing this trend, and consider whether you should make a disclosure of some type or a referral. And the DCAA, for example, has this Form 2000, which is a form that they can fill out for making referrals to the OIG or making referrals to the Department of Justice. And this Form 2000, the DCAA, as a general rule, everything that leaves the agency has to be reviewed by a supervisory auditor. An example, the only exception I'm aware of that does not have to be reviewed by a supervisory auditor are these Form 2000s. So you can have a relatively junior person write something in a Form 2000 and make a referral without it being reviewed by a supervisory auditor. Many of these different, there's two slides here with various topics, and their financial statements is one of them. Financial statements, in accounting world, there's financial accounting, which is financial statements, and it relates to the entity as a whole. If you want to know the profit or loss or the assets or liabilities of an entire entity, the whole company, that's where you look to financial statements. If you want to know the profit or loss on a particular contract, you can't see that from financial statements. That's cost accounting, not financial accounting, but cost accounting. But there can be fraud related to misstating financial statements. More often than not, that falls under the SEC, Securities and Exchange Commission. But that's one of the topics. Labor costs, as shown here, indirect costs, incurred costs, the tone at the top, contracting in general, and you can see here the various things under contracting, from bid rigging to subcontract pricing to missing documentation, and there's even more information behind each of these in the DoD OIG website, so auditors can read this and get some sense of the types of things that are there. And then they have a list of red flags and indicators. The indicators doesn't make sense to me because it says that these are just things that they don't necessarily indicate fraud, but they are examples of types of things to look for. And here's a list of topics, from cross-charging, like we talked about earlier, working on one contract to charging your time to another contract, to credit card fraud, which is not limited to government contracts, to billing manipulation, cash larceny, et cetera, et cetera. And the list goes on, even more topics, to things, Truth in Negotiations Act or unbalanced bidding, like in bid protests, to leaking bid data or manipulation of bids, or things of that nature, product substitution. I'm just going to focus on a few of these that are in red, but things like complaints from vendors or subcontractors reporting that they've received pressure for certain things. So, say a subcontractor goes around the prime and comes to the DoD IG to see if something is inappropriate. Overly friendly interaction between government employee and contractor. Government official has an undisclosed outside business. Requests for sole source procurements. It's easier sometimes to do a sole source procurement than to have competition. But if there is an excessive use of sole source procurements, the auditors are encouraged to look at that further. Unexplained or unjustified favorable treatment of a particular supplier. Payment of unjustified high prices. Unexplained or unusual favoritism of particular contractors. These are all under the category of conflict of interest. Government personnel providing proprietary information. Numerous sole source contracts awarded to the same contractor. Those are things that they're saying. They're not saying this indicates there is fraud. These are just things to look at further and possibly in court. Inadequate documentation of contract violations by contracting personnel, payment of unjustified high prices, and then this is defective pricing, which is kind of a classic. I mean, there's labor mischarging and defective pricing are, in my experience, a couple of the most often experienced types of fraud. So the types of things listed here under defective pricing are also listed in the DCA's audit guidance and other places.
Greg, I have a question. If you have finished performance and DCA comes in and audits and they find that some of your costs are expressly unallowable, is that something that needs to be disclosed?
Yeah, I don't think of that as credible evidence of fraud, and I think of that as just a normal contract action that between the parties. So I think there's been an incurred cost submission, and the contractors proposed some costs that the contracting community, the audit community is saying no, that's not just unallowable, but expressly unallowable. And I'll just note that there have been a couple of recent decisions. I personally believe the DCAA has kind of overreached over the last 5 years in saying that some costs are expressly unallowable. And a couple of recent board decisions, ASBCA decisions, have kind of reined in that. And I understand that the DCAA is rewriting or editing its audit guidance with respect to expressly unallowable costs.
Remember, too, that the government has some inexperience occasionally, and sometimes they need to be educated in these particular areas. And it's much better that the contractor help the government get educated, and that's beneficial as well.
Let me follow up on that, Dan. Another question for you. Suppose you have a hotline complaint that the company has charged too much for a particular line item, and you find out that it's true, the company did charge too much, but you have a legal defense. Does that need to be disclosed?
I think that's the kind of thing where you get into, okay, we got to talk to the contracting officer, we've got to talk to the client, make sure that they understand what's going on, and we've got to figure out how are we going to solve it. And maybe it doesn't rise to the level of some type of credible evidence that needs to be disclosed to the OIG. We can get it solved, and I think that falls into the administrative area. Now, I'm not speaking for the government, and I don't have my SDO hat on that I had several years ago when the only disclosures they had when I was the SDO was voluntary disclosures. But I got to tell you, when I was the SDO, if people voluntarily disclose problems with the contracting process, I looked on them much more favorably than when somebody else produced that.
And Joe, thanks, Dan. Joe, I have one question for you. Suppose the company is not following all of the contract specifications. Let's say that it follows 95, but it doesn't follow 5, and it's never performed 5. They just haven't performed those specifications. And there's a hotline complaint. Do you need to disclose that you've been collecting money for a contract where you haven't performed all the specifications?
Great question, and it sounds like an implied certification issue. And you may have to take a look at all the elements of the potential FCA violation. But it sounds like something that could be voluntarily disclosed if the determination is that an MDR disclosure is not required. It's still something that, depending on the exact circumstances, may need to be disclosed in a voluntary disclosure.
The last question for the group that I have here is, have you ever made a disclosure and not been certain as to what kind of due diligence would be needed to determine whether or not the facts amounted to credible evidence for the disclosure, and you were looking for the government to teach you what they wanted you to do?
Well, I'm going quickly to slide 57, which I thought had really good insight on this point. But it says, credible evidence specifies a higher standard than reasonable grounds to believe, implying that the contractor will have the opportunity to take some time for preliminary analysis. I thought that was helpful. I kind of put a couple of stars on that point. When credible evidence versus is a higher standard than reasonable grounds to believe.
And in my current role as, counsel for a government contractor, I think that's fairly high standard. And I certainly wouldn't disclose something to the government that we haven't established yet that there is some problem that needs to be disclosed.
Have you ever made a disclosure where you are not complete with your investigation, but you felt like you needed to because of time and indicated that you would be continuing your investigation?
The short answer to that is yes.
And I've seen that several times, where it had been like 6 months had passed. Still, it was a very complicated situation, and they couldn't establish that there was credible evidence of fraud, but felt like we need to make a disclosure. And maybe the company made the disclosure.
Well, we have to close because of time. I would ask the panelists if they've got any concluding remarks.
I think that the major lesson is that robust compliance is the best practice.
Good point to end on.
Well, and I'll just say, people, our contact information, phone numbers are there. If people want to call, I think probably any of us, to just brainstorm about this, to discuss this, feel free to.
I think we'll make a close. For those of you who have questions that we haven't responded to, make sure you leave them online and we'll respond to them. But we thank you very much for joining our webinar on the FAR Mandatory Disclosure Rule. A copy of slides is available. It's on the handout section online. And there's also going to be a copy of the webinar available on thompsonhine.com, and it should be posted within the next day or so. And don't, as Greg just mentioned, don't hesitate to reach out to any of us directly, and you've got our contact information with the materials. Thank you very much for your attendance and your attentiveness today.